Okay. Councilmember Yaffe,
Here.
Councilmember Tricoche will not be able to attend. Councilmember Salver,
Here.
Councilmember Reed,
Here.
Councilmember Leonard,
Here.
Vice Mayor Fuller,
Here.
Mayor Bruder.
Here.
You have a quorum.
There's a delay.
So do we want to say the pledge? Because we got
Sure.
last time. Okay.
Pledge
2, 3.
allegiance
I
to the
pledge
flag
to the flag of the United
States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay.
Number 1 is approval and authorization for the interim town manager to execute an amendment to the interlocal agreement with Miami-Dade Public School Board to allow the town to operate a summer care program at the Ruth K. Broadway Harbor KA Center during the COVID-19 pandemic in compliance with CDC and county mayor emergency orders. We forwarded the amendment and the waiver for this. I have been going back and forth with the Miami-Dade County School Board for like 3 weeks. We got the agreement, I think, a couple of days ago. We've been back and forth with Frank and them to finalize it. It was finalized basically this morning. That's why it's so late coming to you. We wanted to have it done today so that the school board has an opportunity to also sign. Until both parties have signed, we cannot occupy the school, and they usually don't move as fast as we would like them to. So that is the reason. I apologize for it being so late, so last minute, but camp starts Monday, and we were trying to do this. We do have a plan B in place, but of course we want to use the school facility.
Okay,
I'll move it.
Okay. Thank you. So Marlene, we already have an agreement. This is an addendum to the agreement because of the COVID-19, or is this just for moving? Go ahead. I'm sorry.
That's correct. It is an amendment because of the COVID-19 and because of the liability. They're asking us to assume the liability so that we can operate the camp. So the agreement would not be in place anymore after the COVID-19 epidemic this will be moved after the COVID-19 epidemic is over, or at the camp.
Stephanie, I'd like to say something.
Is this an insurance? Okay, I'm sorry. Go ahead.
No, go ahead. I finished your questions because I just want to make sure because I want to talk about this.
I wanted to.
It's very hard to hear you there.
I'm in a meeting. Okay. Go ahead, Josh.
Okay. I've got a serious problem with this, and I'm going to tell you right now, I'm going to be voting against it very strongly here for one main reason. The fact of the matter is we received an 18-page document that specifically is not just, and Frank, I know you're going to want to say something, but it's not only just simply an amendment, but it refers back to the original agreement with the potential of creating a default on the agreement and throwing out or creating serious issues to the original agreement with 1 hour before with notice. And I think it's obvious that, I haven't had a chance to fully read. I only got a chance to skim through the first part, given the timeline and the emergency notice for this meeting. And I think it's obvious that most, if not all, of the rest of the council has not had an opportunity to really read through this in detail. I think we're premature in the meeting, even though there's a rush to get this before Monday. The concept that we're having this meeting 1 hour after getting the document where nobody here has read it. And I can tell you just from skimming through it, I was racing back to my house to try and be able to participate in this call. But while I got stopped at a drive-through at the bank before I could come over here. I already found what I consider a legal flaw to the agreement. And I'm not going to go step by step with all of them, but if I can find that within the first, 2 minutes of reading and a few paragraphs in, I don't know what else is in this document. And if we make a mistake here, we put in jeopardy our main agreement with the school. So the idea that we're having this 1 hour, and if you had the agreement this morning, then we should have gotten it this morning. And if at the very least, I have no problem coming back and having this emergency meeting again tomorrow, or even having it at 9 o'clock tonight, or any other time when we've all had an opportunity to read this. But if we make a mistake here and something here creates a default on the main agreement, then we're all to blame for this. And I refuse to vote for something that was not given a chance to read. And at least the public also hasn't been given a chance. This is something that came up at the last minute, and it did not need to be an emergency. So that's my problem with this here, is if I find one flaw within the first 2 minutes, I don't know what else is in a document that you're asking us to sign on behalf of the town.
Excuse me, Josh, you mentioned an 18-page document. Are we talking about the same thing, the First Amendment to joint use agreement with a waiver?
I'm looking at the 18 page. Well, so it says 18 pages of the, for the agenda.
Oh, because that's the whole agenda package.
Right, but I'm saying, but that should tell you the fact of like this, when I say we didn't get a chance to do this,
right.
I got this.
To make sure we're talking about the same document.
Yeah, I guess, but still the idea is I have not had a chance to read it. I think from our, I think it's obvious here, everybody else here hasn't had a chance to, or most everybody has not had a chance to go in depth. And if I found a flaw right off the bat, while I'm in a drive-through lane somewhere, what else is in this document? And I have a problem with that. I think there's no reason why this can't happen, 8 a.m., 9 a.m. tomorrow, or even 9 o'clock at night. But the idea that if they waited till 2 o'clock to hand us this document for where we're trying to race to get here for a 3 o'clock meeting, and if there were early drafts, at least give us something to see. That's a mistake. That's I'm sorry, Marlene, I told you, but this is a mistake by staff to hand us this document that commits us to something significant, including our relationship and our contract with the school long term, not just some amendment. If we're given this 1 hour before, that's a flaw.
Frank, can you answer that?
So would you like to?
What's Stephanie?
Mayor, if I can.
Would you like to adjourn? And okay, go ahead, Marlene.
Stephanie, you don't have any audio, so.
I can't hear you.
The audio is pretty bad. Frank, can you answer the question that I think Josh asked me about a specific language?
I can. Yeah, I think what Councilman Fuller is pointing to is on page 4, 6D, which is added, which states that the part material breach, which doesn't mean a small breach. It means a breach which goes to the heart of the matter. It's the equivalent of gross negligence versus negligence. It is a material breach.
Frank, I didn't get that far. You're addressing something I didn't even get that far in the agreement. I found the flaw earlier on. That's my point. I was racing back to get here for a meeting.
Okay, tell me what.
I'm trying to find it again, because this is the problem when you guys give us this with no time.
Josh, while you're finding it, I have it in front of me. And here's the question, Frank.
Sure.
There are a couple definitions in here. This amendment is referred to as the
First Amendment.
First Amendment, right? But
the underlying agreement's agreement.
Okay, but Frank, when it's talking about a breach, I understand if we breach the First Amendment because we don't follow CDC guidelines and so on and so forth, then the First Amendment should be terminated.
Exactly.
But this refers back to the entire agreement being
underlined.
If there's a breach of the First Amendment, and I think, I don't want to put words into Josh's mouth, but I think that's what Josh is referring to. You can shut down the camp program if we're not following guidelines, but to completely void out and terminate the joint use agreement, I don't want to be in that position of having them come back.
That's exactly the problem. And there's something earlier, I can't find it right now because I'm trying to talk to you guys at the same time, but it talks about, it specifically states that if they receive notice, doesn't even have to be actual there. If there's notice that something is, that we're not following something, that constitutes a material breach. So you've given a definition and created a material breach and hit that realm simply by receiving notice. That's a flaw.
Well, the material breach has to do with the underlying agreement, not the First Amendment.
No. It says I disagree, Frank. It says it becomes a material breach of the agreement, which is defined as the original agreement, not this.
Correct.
But it says notice. I'm trying to find where it is on this. It talks about the fact that if they receive notice of the problem, that constitutes material breach of the main agreement. So whether or not there's an actual breach or any other problem, the way this reads, I'm trying to find it. I apologize for, like I said, I'm racing around, and this is the problem with getting this at the last minute. It talks about that if they receive, here on page 3 of 6 of the original portion, it says in section 2, it says receipt by the school board of, and it's not even capitalized, so it means it can be informal, of notice of noncompliance by the town with the foregoing procedures and requirements shall be deemed a material breach of this agreement, and defines agreement as the original agreement. So it doesn't even talk about a formal notice. If technically, if we have somebody who wants to be a troublemaker or something else and provides a notice that we're not following one section or one little thing, that constitutes a material breach, and we've got a problem when we have to renegotiate. They have the ability to renegotiate the original agreement. I'm not opening that door.
Okay, Stephanie, I had my hand up electronically for a couple of minutes now.
Okay, go ahead.
All right, I have a suggestion here, because I think we should leave the lawyering to the lawyers. And I think it might be appropriate at this point just to say, hey, look, let's make like a school board contract or school board agreement committee, and appoint Josh and Bob, or Josh, Bob, and whoever else on the council wants to be on that committee, and just hash out the legal terms. Because what they're, I don't know, I don't know law. I'm not a lawyer. And I think, if there's some, legal aspects, I really can't contribute. I think it's the will of administration and the will of the council to do our best to make sure that camp will go forward. So can't the council agree on allowing like a subcommittee, a legal, a school board agreement committee to move forward in all due speed, to be able to get the camp open as soon as possible, and give the administration and these guys the authority, along with the city attorney, to make a decision, wordsmith the agreement so it's not negating our previous agreement with the school, and move forward on that basis. Because honestly, hearing all this legal banter going back and forth is I can't contribute. I don't feel like I can contribute, and nor do I want to really hear it.
Sure. Or here's a, if I may, Mayor.
First of all, we can start camp without. Yeah. Go ahead.
Just as a suggestion to follow up on Councilman Salver's point, perhaps if I'm given the latitude to do two things: one, to provide a notice and opportunity to cure as a material breach, and two, if there is a material breach, the only thing that gets canceled is this First Amendment. If you were to approve this with those two conditions, I can easily make those changes and go back to them. And if those two conditions are met, then the town manager would have the ability to sign it.
Frank, let me address one thing if I can on that. Sure, sorry.
All right, first of all, we can start camp without actually, right, Marlene, having this done in a rush.
No, we can only start camp in our own facility. We cannot use the
right.
facility.
I understand that, but I'm saying if we can't get it done from today to tomorrow, we can, to Isaac's point, we can start camp and have the legal bashing out, because I don't want to do anything that's going to compromise our agreement or have to go back to the drawing board as far as our interlocal agreement. To tell you the truth, I don't even know why just having the COVID-19 should have been enough for them, that they don't need to attach it. It should have just been an amendment because of
right. It should have been like a condition. It should have been a condition, okay? You need to sign these releases, right, and everything else stays the same. So
I think that what Frank proposed,
right,
would fix this issue. It is more desirable to use the school facilities, because we can separate the kids better and we can run the program better from there. We are prepared to proceed with the community center if we have to. But also here is the agreement on the tennis courts, which they have asked me to shut down, and I have shut down. There is no program running today. So they are also in control of, they're the owners of the land where we have the tennis courts, and we have a long-term lease with them, but they're also asking us in order for us to operate the tennis courts to sign the agreement, which is item number 2.
Can I make a comment on that to Josh's point, about just getting notice and being in breach? Some resident of the town called and filed a complaint, which then resulted in the principal of the school demanding, apparently on behalf of the school board, that we shut down our tennis programs, really for no reason at all. So that, leads me more to concern about the amendment, because some third party could come along and just make some false accusation or some baseless accusation about our program. And so, Frank, to your point, we do need notice and opportunity to cure and make sure that the only thing that would be canceled, as you said, or terminated would be the amendment, not the original agreement. Make sure that, that the notice is proper. Notice goes to somebody making a phone call to the school board or the principal, but we need to get a copy of any notice that goes out before it becomes a default, and so that there's an opportunity to discuss and make sure that the issue is a valid issue.
That's exactly I appreciate it, Bob, because that's exactly my point. But can I say one thing, Stephanie? The problem is, Frank, I understand what you're trying to do to make sure everything moves forward. But I still have the same problem where if I found that flaw in the first 2 minutes of reading, and I haven't had a chance, like I think everybody else or most people out there in the council, to read these documents, I don't know what else is out there. So the idea that we're giving you the okay, that may have solved this one problem if we can give you those rights, but I don't know what else is there, and I'm not comfortable doing something that may put our agreement, our main agreement with the school, or any other agreement, or any other portion of the school with liability. I'm sorry, the town on liability at risk, without having a chance to read it. So I can't support signing a document that I haven't read. I mean, if you give us more notice, even in a couple, even first thing tomorrow morning or a few more hours, I probably would have no problem. But yeah, I'm not agreeing to anything where you hand me something and say sign it. It's just not going to happen.
Let's just do this. Why don't we just come back?
Well, I have another question.
Yeah.
Well, I have a question. Why we lease the tennis courts from them, and tennis is allowed. I mean, the mayor, the county mayor already permitted tennis courts, Marlene. So why are we just?
Their position is that they are the landowner, we are the lessee, and they want some reassurances before they let us open. It's like any other business that is opening anywhere. They're just asking for us to sign, to have people sign a waiver and to comply with the COVID-19, the CDC guidelines and the mayor's orders formally. So, I understand the short notice. And I understand some of the concerns. We're saying we're going to address them. We're asking for permission to go back to the school and renegotiate that. We cannot have a meeting tomorrow morning, or you can have it without me, I guess. I can't have a meeting because I have another meeting scheduled from 10 a.m. to 1 in the afternoon. We can probably have something later tomorrow. I just it's everything. Getting back and forth to the school.
So may I suggest that Josh and Bob, who obviously know more about the details of this, I agree with Isaac. I think that maybe you two should be maybe a subcommittee.
We can't.
Who goes?
We'd have to have a public meeting. It's sunshine. We can't. It'd have to be a public meeting. It doesn't. We can't do that stuff.
But just can we just have Frank go back, change it, and then give it to us, and then we can have another meeting? This is not.
He can make some changes, then come back. I'm just not agreeing to sign something until I've read a chance to read the whole document.
So we'll have another meeting tomorrow. We'll do it tomorrow. Frank has a whole day.
In the meantime, Josh, will you read it and let Frank know what are your issues, and Bob also what are the particulars separately in the document that you don't like, so that
I can read it tonight. I moved a few things so that I could be here for the 3 o'clock. I can after yeah, later on tonight I can do it. I can't do it right now. So I mean, I can.
No, that's fine. That's fine. But I'm saying, well, we could have a meeting maybe tomorrow afternoon. Would that give you and Bob plenty of time to read it and have a discussion in the morning?
Well, I can't have a discussion with Bob. I was saying is,
No, but you
the
can
best
talk
I can
to-
do is I can call Frank.
You
No,
talk
no,
to
no.
Frank. though.
You can-
With Frank.
Just for logistical
Okay.
purposes, I'm going to make the revisions right now. Josh, or Bob, if you'd like to call me, individually. I plan on getting those revisions to them within 35 minutes. So if you want to take a quick look, and give me a call, I'm happy to.
I can do it in a couple hours. I can't right now. I mean,
Okay.
yeah.
But I'll get
But I can-
moving on it. I know exactly what the issue is and the concern. And quite honestly, I think their concern is if we're not, anyway, I'll deal with that issue.
Okay.
All right.
That's fine.
Okay.
Okay,
Alright,
so
so-
do you all want to come back tomorrow?
Yeah, we'll come
And
back.
then we can revisit it? Okay.
Mayor,
Carrie?
Arrange on
Yes.
a
Mayor, I just wanted to say, in case that we don't have anything finalized tomorrow, I will schedule the meeting for sometime next week, and we'll go ahead and proceed with our Plan B to open it in the community center.
Okay.
But we can get something scheduled tomorrow. I don't think there's a problem. We'll
Yeah,
find a way
that's
to get it.
Haven't been getting replies to the school board as fast as we would like. So we can get it to them, but that doesn't mean we're gonna get it back with.
Right. Well,
with
that's
step approving.
That's a whole nother.
Yeah, our
That's on
issue
them.
has been, our issue always with the school board is we're fast, they're slow. And quite honestly, I was surprised that they agreed to many of the items I wanted. And as a matter of fact, they copycatted and used our waiver agreement as well. So easily done
okay.
on our end.
Okay.
All
Okay.
right.
So let's
right.
do that, and you'll let us know whether we're gonna have the meeting tomorrow or if we're gonna have the meeting on Monday. What is better for everybody? Since I don't think we're gonna get it back from the school board tomorrow.
Well, it's
Can we just
possible.
schedule it?
Let's try to get it as soon as possible.
It's
Yeah.
possible. I will get it to the school board within the hour. I will call her and talk to her about it too, so that they understand the concerns. And finally, see if we can get it tomorrow, so that tomorrow at 3 p.m. we could have another meeting if necessary.
Frank, is this all necessary? What if we tell them, we don't want to sign any new agreements? We'll have the participants sign waivers, we'll have the tennis players sign waivers. Don't we have certain rights under the old agreement? I mean, the world didn't change that radically.
Yeah, that's been my point to them, that one, we're allowed to use our tennis courts under the executive orders and under our possessory interests, which their response was, we don't care, we own it and we control it. We're not going to give it to you unless you agree to comply with the executive orders in the handbook and the like. To which I responded, we have to do that anyway. You're asking us to codify something we're already entitled to do. But that is their position. They're not going to allow us to use it unless you want me to go into court. And we'll have a hearing and on an injunction motion, but that'll take,
But I'd rather have them take us to court.
well, we
If we have
can't,
an outstanding, let them take us to court. We'll sign the waivers that we need to have signed. And, we're operating by the original agreement, and we're going to use the property that they're bound to allow us to use by our agreement, and move forward on that basis. And if they have a problem with it, let them take us to court.
and then you're going to have a bunch of kids in the
I-
community.
From a
running.
practical standpoint, we want to get the camp open. So,
Yeah.
I hear what you're saying, Isaac, and generally I would agree with you, but I don't know how they would shut us down. I mean, they ordered Marlene, the tennis courts are shut.
Yes.
You listened to them, you complied. So, so right now we can't use them, and next week we can't use the school facilities for camp. So this could go on for weeks, by the time somebody files a lawsuit, gets an emergency injunction hearing.
Yeah, the camp will be over.
What? Right.
Yeah, the camp will be over in 6 weeks.
Right, camp will be over. So, that's not going to assist us. But
And just so you know, that's why I limited the language to only during the state of emergency in which the First Amendment will be gone. I don't want to be dealing with this once the state of emergency is over.
No, I agree with that.
All right, well, that's good. All right.
Okay, so tomorrow, 3:00?
Sure.
No, Mayor, I'm not gonna call a meeting until I know that we have everything back and, until I send it to you. So, we need to, I don't wanna face the same, criticism that you didn't have enough time to fix the last version. So, I will wait till I get the final and then I will send it to you and we will set up a meeting, most likely at this.
Okay.
Yeah, just so you know, logistically, Marlene, I'm going to call her right now, talk about a couple of these minor issues and see if I can get some movement on those two issues.
Okay.
Has there been any discussion about the basketball courts? Or?
Basketball courts are there, part of their facilities.
No, I understand that. I mean,
If they allow us to run camp and use their facilities, we will have access for camp only to the basketball courts, not to open to the public. They have not said that that could happen.
Frank, who are you
What
dealing
about
with?
the fields open to the public?
They have not said that that can happen. They are only allowing us to use it for the camp.
Frank, who are you dealing with at the school board?
I'm dealing with the assistant superintendent and their legal staff,
And Iraida and everybody else is copied.
this whole
Everything.
group. And I can tell you from our prior dealings with them, they are usually very slow and very hard to deal with. This issue is no different. However, I'm pretty sure we can get this taken care of. I think everyone should understand and appreciate the two remaining concerns.
Okay.
Okay,
All
so
right.
let us know.
Okay,
All right, so let's go.
All right.
thank you.
Thank you, everyone.
All right.
Bye.
so we're adjourned.
Okay.
Bye.
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 Yes, adjourned.